Marlisa, did you set a time with the police department?
I have sent, I have called them and had Huron dispatch a car their way. I've sent it to Crystal and asked them to her to be on for 9 o'clock.
Thank you, ma'am.
Hi, Marianne.
Hi, Steve.
Hey, Tom, how you doing?
Good. How are you?
Good. Hey, I've been having a lot of trouble with Hartsfield's court.
Yeah.
Trying to get letters of authority. I literally email every day. So
I understand. I understand. Did you get our letter on that other matter?
I
Oh,
haven't yet. No.
checks on the car on that. Hubert.
Yeah, I know what it is. Yeah, I haven't got it yet though.
Okay. We mailed it out Wednesday,
Oh, okay.
Thursday. Just letting you know.
Okay. Judge McNally was asking about you last week when I was
You see?
when I was over there. It's like, what's Tom DePietro doing these days? I said, you know what? I just saw him. He's doing good.
Yeah, yeah. I like Mike. I haven't been down there in a while. You know, I hate to say it. I used to enjoy appearing in front of his father. Back in the old days at the 33rd. Yeah, I think we emailed, the court said email the judge's courtroom, and I think we did that too on Hay.
Yeah.
We didn't hear nothing either. She was so anxious to open and close in 30 days. Anyway,
Yeah, I've had one, Tom. It's going on 60 days now. It's same type of deal. I emailed and e-filed the acceptance the same day as my hearing. In fact, I was in Florida at the time, and I didn't want to change the date, so I did it from Florida, and I don't know what the problem is. And not only that, I CC'd her judicial assistant and her clerk, their personal emails.
mhm.
So
Well, things seem to go up and down there. You know, sometimes things click and sometimes things don't.
yeah.
I'm trying to figure out what I'm doing here today.
Hey, Todd.
Hey Steve, how you doing?
Good. How are you?
Good. Did you get my the discovery last week? I think
Yeah, I
Friday.
got it. Yeah, I
Okay.
did. Yep. I think we'll just ask the judge, what do you just want to ask for a trial date or something?
Uh Probably one last pretrial with the outstanding
Yeah, that's fine.
discovery. Yeah.
Okay, that's cool. All right.
Um, I was hoping we were gonna get it settled.
Yeah, how far apart were we? We were like 1,500 apart, weren't we? We weren't that 2 grand maybe?
Roundabout. I was hoping we'd be able to work to it, but your guy was a little steadfast as to his position.
Yeah.
I'm hoping it will soften as we move forward and he incurs attorney's fees.
Yeah. I'll see what I can do.
Okay.
All right.
Morning, Mr. DePietro. How are you? Oh, you're muted.
I said, good morning. How are you?
Hi, I'm good. Thank you. What case are you here for this morning?
I got a notice to appear on Papazian versus Best Asphalt et al.
Sandy, did you just hear that?
Yeah, do you have a case number,
I
Mr.
did.
DePietro?
Yes, it's 2400518. I don't know. I don't know anything about it other than that my client got a notice to appear.
That is for 10 o'clock. Are you here for J&M Towing or Romulus Police Department?
Oh, no wonder you don't have me. I didn't realize it was 10 o'clock. Well, yeah, I guess it's the towing company, and Mr. Papazian is the owner of a vehicle that was seized at my client's request, and J&M is charging storage fees.
So at 10 o'clock, we'll see you then. You're here for Romulus Police or?
At least I got to chat with Steve and see you. See you later.
Bye.
Thanks, Sandy.
You're welcome.
This is 2301787GC, Kenneth Welch versus Michael Mockridge and MS and Company. May I have your appearances, please?
Good morning, Your Honor. Todd Ennis, P6112 on behalf of the plaintiff, Kenneth Welch.
Good morning, Your Honor. For the record, Steve Robinson appearing on behalf of defendants.
Good morning. Today is the day and time for the second pretrial in this matter. How are we proceeding, Mr. Ennis?
Your Honor, we did mediate this. However, we were unsuccessful in getting it resolved. I've served some discovery on Mr. Robinson. I think we'd probably like to get another date, about 45, 60 days, and then probably pick a trial date from there.
I concur, Judge.
You're saying the trial date at that 60-day mark, Mr. Ennis?
I'm sorry, Your Honor. Another pretrial at 60 days. If we don't have it resolved at that point, pick a trial date then.
This case is already bumped around for a little bit. I'm not inclined to adjourn for another 60 days. Do you believe that June 4th is too soon for you to make progress in this matter?
I guess it really depends on Mr. Robinson's ability to respond to discovery.
Well, I can get the discovery by June 4th, Judge.
That'll be fine.
Will you be ready to return by June 4th, Mr. Robinson?
Yes, Judge.
June 4th at 9:45 a.m. back on Zoom. And if you haven't resolved it, we'll pick a trial date on that time, on that date and time.
Thank you, Your Honor.
Was there anything else, Mr. Robinson?
No, Judge.
Anything else, Mr. Ennis?
No, Your Honor.
Do you anticipate the filing of a motion, Mr. Ennis?
Unlikely, Your Honor. But we'll see what I get in discovery. There could be a reason there, but I doubt it.
Mr. Robinson, same question.
No, Judge, I don't anticipate any motions.
Okay, thank you. I will see you back on June the 4th at 9:45 a.m. Have a wonderful day.
Thanks, Judge.
Thank you, Your Honor.
also. Take care, Todd.
Take it easy, Steve.
This is 2302716 GC. This is Andover Farms versus Nwoko. May I have your appearances, please?
Morning, Honor. Brian Kelly on behalf of Andover Farms.
Your Honor, Ike is here.
Good morning. Today is the day and time for the adjourned pretrial in this matter. How are we proceeding, Mr. Kelly?
Thank you so much, Your Honor. Your Honor, as you may recall, the parties agreed to attend mediation with Judge Green at our last hearing. We attempted to schedule it. The defendant subsequently sent a letter to the court and to our office indicated he no longer would be cooperating with mediation and wanted to proceed with this matter. We sent an offer of judgment to the defendant on April 9th, 2024 for $75 and no response was received. At this point, we are left with no option but to ask the court to set it for trial.
Mr. Nwoko, is that your understanding of where we are this morning?
Your Honor, yeah, my understanding, they wrote me a letter telling me that I still owe $75. Even though in my previous letter with them, I said that I don't think I owe any money. But since they insisted that I am owing, that's why I'm saying I'm not owing anything. But if they are insisting on that I'm owing, then I might as well go to court.
What Mr. Kelly indicated was that he believes the matter is ready for trial to be scheduled. Is that your understanding, sir? Do you believe the trial is ready to be scheduled?
I don't know if I'm completely understanding that. I mean,
Is May the 21st too soon, Mr. Kelly?
May 21st. Your Honor, if we could do the week after that.
They'll do everything.
So I don't.
After that would be June the 4th.
You can hear them. Make this,
June the 4th.
you're right there, so.
Okay.
But
And
they'll,
sir, if you would look at your calendar as well, the
Doesn't
court
matter.
is
If you have
anticipating
any
the scheduling of a
problems,
trial on June the
okay.
4th.
June the 4th will work for me, Your Honor.
How would I know when they talking to
Oh,
me?
they'll call you. They'll tell you.
Ma'am.
I'm sorry, I'm not sure if I spoke over. June the 4th will work with my schedule, Your Honor.
I heard you. Thank you, Mr. Kelly. I was waiting for Mr. Wokel's response. Are you available on June the 4th at 10 a.m. for trial, sir?
June the 4th. Yeah, I should be.
June the 4th at 10 a.m. Sir, are you asking to appear in person for trial or on Zoom?
On Zoom it would be fine.
And Your Honor, I'd ask to do in person, but allow witnesses to appear by Zoom.
Sir, do you have an objection to appearing in person?
Yes, Your Honor, because I work nights and I come back a little late. So the Zoom is working really fine for me. So
Sir, the court's concern is that if one party's in person and the other party's on Zoom, it impacts the ability to share documents. But if you wish, sir, if you wish to appear by Zoom, that's your absolute right. Mr. Kelly has indicated that he will appear in person and that witnesses have the ability to appear by Zoom.
yeah,
Because you are not.
I will appear by Zoom. Sorry, Your Honor, to cut you off.
No, don't be, no, sir, don't be sorry. I'll encourage you to think about how you'll handle your case. So if there are documents that you'll be referencing, the court does have the ability to allow you to share your screen. If there are documents you want to serve on Mr. Kelly beforehand, and you want to provide a copy to the court, that might make the review and presentation of evidence a little easier for the party. So you're not required to just thinking through how to best move through the case on June the 4th. Unless there's anything else, June the 4th at 10 a.m. Was there anything else, Mr. Kelly?
Your Honor, I will be filing a motion regarding the offer of judgment that was rejected, as well as attorney's fees. So I just wanted to make the court aware of that.
Understood, sir. And I saw the proof of service in the file from the offer of judgment. Sir, is there anything else before you leave this morning?
I would like to understand what he just referenced, because that's not quite clear with me. I'm not exactly sure as to what he just said right now. Could that be explained to me? What that means, please?
The only thing that Mr. Kelly said is that he anticipated filing a motion based on your rejection of the offer of judgment. He could have that, this is absolutely right to file such a motion. That's all he was saying, that he was filing that motion.
For rejection of offer of judgment.
Yes, sir.
Well, I'm trying to understand, is it a judgment based off of the arbitration, or is it the judgment that is gonna come on May when will appear?
Respectfully, sir, the court cannot help you defend the case that's been filed against you. What the court can do is encourage you to seek legal assistance. You can do that through the State Bar Referral Service. You may go online, michiganlegalhelp.org, might give answers to your questions.
Okay,
But the court has set the trial date and heard Mr. Kelly's assertion that he may file a motion. That resolves this. Well,
may I
that
say
concludes
something
this.
real quick?
Yes, sir.
I think I want to settle. I will pay them their $75 and call it quits.
Your Honor, I would have to run that by our client. But if we could schedule this, and then I can reach out to Mr. Moku separately, I can talk to him about taking care of the upcoming hearings.
Do you want to speak this morning? Do you want
I have to
be moved into a
reach out.
breakout room?
Oh, I'm sorry, Your Honor. For talking over you. I have to reach out to a client, and I know they're out of town right now, so it's going to take me probably a couple hours to get a hold of them.
Understood. So, Mr. Kelly will be in contact with you. If the parties are able to resolve the case before the June 4th trial date, please notify the court, send the appropriate paperwork over to the civil department so that the trial date may be removed from the court's calendar, okay? That concludes this matter. You're both free to go. You have a good day.
Thank you so much, Your Honor. Have a good day.
Thank you. This is 221939 GC, Beaumont Health versus Crystal Taylor.
Hello, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case. I did not see
Today was the day and time scheduled. I'm sorry.
I didn't mean to speak over you. I didn't see Miss Taylor in the waiting room.
Yep, I'm here.
Oh, she is here.
Sorry, Your Honor. Crystal Taylor.
Mr. Burke and Ms. Taylor, do you need to speak before we proceed with this objection to garnishment?
I don't think so, Your Honor.
No, I don't think so.
Ma'am, it's your objection. Please proceed.
Yes, Your Honor. I'm wanting to. I filed this objection due to the fact that the judgments that were against me had been paid previously back in. I actually have a list of all of the fees and when they were paid in full. And they go back all the way to 2019, I believe. I did try sending these back in 2022 to the plaintiff. Not sure if he received them, but what I'm asking is for my for the garnishment of wages to be completely dismissed and also reimbursed.
I'm sorry, Ms. Taylor, are you saying that you paid what's owed in full before, ma'am? You're answering a question I haven't finished asking yet. Are you
Sorry.
saying that you paid in full the case before it was even filed?
Yes, ma'am.
Okay. Was there anything else?
No, ma'am.
Mr. Burke?
Your Honor, I respect Miss Taylor as I try to respect everybody. If she would take my email address, I agree with your question to her. This was filed in 2022, and if she believes she paid it in 2019, candidly, I'm not certain why she didn't put that into her answer, or at least I didn't see that she did. However, if there is an accounting issue, I would ask that you allow the GARN to proceed, and I will give my email in open court or directly to Ms. Taylor if you'd like. And if she can send me an accounting, we will get with the creditor and try to see where the monies she believes she paid went and report back to you and her.
Ms. Taylor?
Yes, Your Honor.
I guess I'm a little confused. You're saying that this case started in 2022 and you're alleging that you paid it in 2019.
Yes, Your Honor. So actually, the charges started in 2019 and ran up to 2021. And all of those charges actually were paid previously to the judgment. And Your Honor, if I may add, I did not know that my wages were being garnished until last week. And I had to contact my HR department to get that letter because it was never served to me. And how I knew about it, Your Honor, was I received an email from ADP, and of course I thought it was a scam. And once I got my pay stub, it said garnishment of wages. I had to take some time off work to figure out what was going on, why I was being garnished. There wasn't any clear explanation, and I did have to take more time off to go to the court and find out why, get copies of everything that was submitted.
Mr. Burke, what is the balance on the judgment that entered back in 2022?
Your Honor, I apologize. I only received this objection in the mail yesterday, and I did not pull the case. We believe that obviously the court granted a valid judgment against us. In all due respect to Ms. Taylor, she had many opportunities to respond to the lawsuit. I'm certain we perfected service through the process server. For her to say that she just found out about this is a little unique because letters had been sent, lawsuits filed, as you know, judgment rendered, and then the garnishment. But I will finish with what I said at the beginning. If you'd like to take my email, I'm happy to see any proof she believes that this was paid.
Mr. Burke, the court will move you and Ms. Taylor into a breakout room at the conclusion of this hearing. My question to you was, what's the balance? And you're saying you don't have the balance that remains due on the judgment with you right now?
That's the only answer. That is correct, Your Honor. That does not mean, obviously, I cannot get it in the next 20 minutes or so when I'm back candidly out of court and back in front of my desk. And I will get it for her, of course.
Okay. The issue is that the objection alleges that the judgment has been paid, and Mr. Burke, it does not sound as if you are in a position to definitively provide to this court that the judgment has not been paid. That's the answer I'm trying to get from you.
Your Honor, if you'd allow a breakout session, I will have the answer while she and I are in the breakout session, and then can report it back to you.
Ms. Taylor, do you have, Mr. Burke indicated he needs 20 minutes to do what he's doing. Do you have time to wait for him to do that?
I'm actually sitting in my work's parking lot, Your Honor. I'm a single mom. I can't miss work. I can wait 20 minutes at most.
How about 5 minutes, Your Honor?
5 minutes. We'll move you into a breakout room. I'll recall this case at about 9:30.
Thank you. Thank you.
Thank you. This is 2400731 First National Bank versus Amy Mitchell. May I have your appearances, please? There are attorneys sitting in the waiting room. If you would bring them in for me, please. This is 240416 FY, State of Michigan versus Kobe Langford.
Crystal Marie Medina, Your Honor, on behalf of Mr. Langford. I'm not sure if he's out of the breakout room yet. I am not seeing him.
I see him. Let me get him out.
Thank you, Your Honor. Nice to see you, Judge. Happy Tuesday.
Happy Tuesday, Ms. Medina. Good to see you. Sir, would you state your name for me in custody in Huron?
Kobe Leon Langford.
Thank you, Mr. Langford. Today is the day and time scheduled for the arraignment in this felony matter. Ms. Medina, how are we proceeding?
Your Honor, we would waive formal reading and stand mute.
Thank you. Sir, were you able to hear Ms. Medina just now?
Kinda went in and out.
Ms. Medina has indicated that she's waiving your right to have a formal reading of the complaint against you and is having you stand mute to the charges. Sir, you have an absolute right to be represented by an attorney in this felony matter going forward. If you're unable to retain an attorney through your own resources, or if that of friends and family, the court is able to appoint one for you. Attached to the front of your file was a request for a court-appointed attorney. The court has signed that. You will be assigned an attorney going forward. It will not be Ms. Medina. It will be someone else who relies on the information contained on that form to be in contact and communication with you. Sir, you also have a right to be considered for pretrial release. There is a recommendation from from Sumter Township asking that your bond be set at $50,000, 10% with the conditions that you not purchase, possess, consume alcoholic beverages, drugs, or weapons. Ms. Medina, what say you to this bond recommendation?
Your Honor, I would ask that the court consider a personal bond. This is, while a very serious matter, it is non-assaultive in nature. My client is 22 years old. He maintains stable residence in Belleville with his parents, is my understanding. He is not currently on probation or parole. My understanding is that he's employed at Tornado's Pizza in Belleville, Michigan, and he's been working there for approximately 7 to 8 months. He understands he needs to come to court, Your Honor, and I don't think right now, at least on his person, does he have access to the funds to post a monetary bond. We would ask that the court give him one opportunity to be released on a personal bond and appear at court.
Thank you, Ms. Medina. The court at this time will not assess a personal bond in this matter. Mr. Langford has some other outstanding matters with this court that are currently in warrant status. That being the case, the court will set the bond at $5,000, 10%, with the condition that he not purchase or possess firearms until weapons of any kind until further order of the court. And Mr. Langford, once you are out of custody, you may appear before this court to make payment plans, to have the warrants lifted in the outstanding matters that you have that go back to 2020. Sir, your case will be set for probable cause conference. Marlisa, you didn't give me any dates.
May 15th, 8:30 a.m., your courtroom.
Thank you. Mr. Langford, your return date is May the 15th at 8:30 a.m. by Zoom in courtroom number 1. Again, this case number is 240416FY. Next appearance date, May the 15th at 8:30 a.m. on Zoom for courtroom number 1. Is there anything else in this case, Ms. Medina?
No, Your Honor, thank you very much and have a nice day, or I may see you again, but have a nice day if I don't. Thank you.
Thank you, ma'am. Mr. Langford, I'll see you on the 15th. You have a good afternoon.
Yes, thank you, Your Honor.
This is a recall of 2400731GC First National Bank versus Amy Mitchell. Please state your names for the record.
Amy Mitchell.
Good morning, Your Honor. Jack Francis on behalf of plaintiffs in your record.
Thank you. Today is the day and time scheduled for the first pretrial in this matter. Ms. Francis, how are we proceeding?
Your Honor, we have reached a consent judgment in this matter. It will be for the full balance. However, we have agreed to settlement terms that if defendant pays $5,963.92.
I'm sorry, Ms. Francis, you have to speak up for me, please.
Sorry. Is that better, Judge?
That is, thank you.
No problem. Sorry, I'm not sure what you heard. I'll just start over.
No, you said you've reached a settlement, the settlement terms.
We've agreed to a consent judgment. It will be for the full balance of $8,024.64. However, defendant can pay $5,963.92 over 36 months to satisfy this judgment. And she has given us permission to sign the consent judgment to submit it to the court.
How are the payments going to be made on the $5,963.92?
She will pay on May 17th, $153.92. Then starting June 17th, she will pay $166 for 35 months.
Ms. Mitchell, was that your understanding and agreement of the settlement you reached with Ms. Francis this morning in this matter?
Yes.
So the court will note that we are awaiting receipt of a consent judgment for the total balance with the settlement terms of $5,963.92 that will be paid with a payment of $153.92 on May the 17th and then $166.35 per month on the 17th of each month for the next 35 months. Was there anything else, Ms. Francis?
It was $166, Judge, for 35 months.
Thank you. $166 for 35 months. Anything else, Ms. Francis?
No, Your Honor. Thank you.
Anything else, Ms. Mitchell?
Nope, that's it.
We will actually adjourn the pretrial to June the 4th at 9:45 a.m. That is just to ensure, that's more of a control date to ensure that the consent judgment is received. Ms. Mitchell, so long as the court receives the consent judgment, it will be signed and a copy will be mailed to you at the address we have on record, and you will not need to appear. But I want to leave that June 4th date out there. Was there anything else, Ms. Mitchell?
Nope, that's it. Do you know what time on June 4th?
9:45, ma'am.
9:45, okay.
Thank you. Have a good day.
You too. Thank you. Bye-bye.
Thank you. This is a recall of 221939GC Beaumont versus Taylor. Mr. Burke, you're back. What's the update?
Thank you, Your Honor. I do have some, I'll call it partially good news for Ms. Taylor. The original balance with the judgment and court costs was $1,160.47. We are now at a balance of $625.21. That indicates that that was indicated based on payments that were made directly to the creditor and reported to us. As we still show that balance, I would ask the same request, and I'm happy to offer my email if Miss Taylor disputes that 6/25/21 balance, which is part of the pending garnishment against her that she said was the first time she heard of this case, although again, it was sued and served and judgment was rendered. I am happy to go through an accounting with her and see what she has to offer that would be anything different than that, of course.
Anything else, Ms. Taylor?
Yes, Your Honor, I would like to dispute it. Like I said, I do have proof that everything was paid. I do have the judgment actually in front of me that was signed that I did have to get copies of from the court because I was never served it. And that was a total judgment of $467.07.
She's not adding court costs or service of process, Your Honor.
Let's see. This is damages, costs, attorney fee, total judgment, $467.07.
Anything else, Ms. Taylor?
No, ma'am.
Thank you. The court has had the opportunity to hear from both Mr. Burke and Ms. Taylor this morning, and the court will deny the objection to garnishment. Mr. Burke has asserted the balance that remains due and owing on the judgment. And Ms. Taylor, just so we're clear, the court record shows that the default judgment entered on August 22nd, 2022, and you called the court and spoke with the clerk on September the 6th, 2022. So the allegations that you made this morning indicating that you had payments that you had proof that this judgment had been paid in full before the case was even filed. The court has questions and concerns about that being the case. Again, the objection to garnishment is deemed invalid and denied. That does not prohibit you, Ms. Taylor, from going into a breakout room, getting Mr. Burke's email address. You may exchange the information you have with the ledger he has, and the parties can have additional conversations about the status of or how to resolve the remaining balance in this case, but that resolves the hearing that was scheduled for this morning. Ma'am, would you like the opportunity to go into the breakout room to get that information from Mr. Burke?
Yes, ma'am.
Court
Your Honor,
staff will move you in. After you've had a chance to speak to Mr. Burke, you'll be free to go. Yes, Mr. Burke.
I apologize. I have a 9:30 I have to zoom into. I am happy to give her out loud now my direct line, whatever you would like.
Take the 2 seconds to go into the breakout room to give the email. I have a 9:15 docket and I see the attorneys waiting. It'll only take you 2 seconds. I understand you have another hearing, but ma'am, please go into the breakout room with Mr. Burke, get that information, and you'll follow up with him after he's done with his hearings.
Thank you, Your Honor.
Thank you. This is 2302337 GC Crown Asset versus Gabrielle Rosu. May I have your appearances, please?
Good morning, Your Honor. Navjot Francis on behalf of Plaintiff's Attorney of Record.
Ma'am, I need you to unmute and identify yourself, please.
If it's about me, my name is Dorina Kasten, but I was called for Dorel Blaga.
Ms. Costin, what is the language that you'll be translating?
I will be translating Romanian language.
Romanian. Would you raise your right hand for me, please, ma'am? Do you swear or affirm that you will translate English into Romanian and Romanian into English to the best of your ability?
I will translate English to Romanian and Romanian to English at the best of my ability.
Thank you, ma'am. It appears that Ms. Rosso is driving. When she's done driving and she's parked and she's ready to give her full attention to these proceedings, we will continue.
Okay, can you give me 1 second, please? Because I'm gonna park in a parking lot. Yes.
Ms. Francis, have you been into the breakout room to discuss this matter with Ms. Rosso yet?
No, I have not.
When she parks, we'll move you, Ms. Constant, in with Ms. Rosso, and when you're done, please, everyone come back to this main session.
Thank you, Judge. I do have one other that I do have an agreement.
Which is that, ma'am?
LVNV funding versus Gantt.
Thank you. 2401097 GC LVNV funding versus Dorothy Gant.
Navjot Francis on behalf of plaintiff's attorney of record, Your Honor.
I know Ms. Gant is down in this court's break, a Zoom room. Let's get her to get her video turned on, unmute herself, and to state her name for the record.
I'm calling security, Judge, for help. Hi.
Mr. Norton and Mr. Haddad, have you spoken this morning?
I don't see Mr. Haddad, but we have not.
He's here. Let's get you moved into a breakout room so you can, if you need to speak, I'll say it that way.
Yeah, I'll speak to Mr. Norton.
Okay,
Thank you.
always, yeah, sure. Thank you.
Help is on the way, Judge.
Thank you. Ma'am, would you state your name for me, please?
Dorothy Gant McKinney.
Thank you. Ms. Francis.
Thank you.
Navjot, I'm sorry, Judge. We have reached an agreement for a consent judgment. The damages are $734.39. Then cost of $102.08. Statutory $75 attorney fee for a total of $886.47. Defendant has made one $25 payment, making her total $861.47. She will then pay $25 per month beginning 5/30/24 and until the judgment is paid.
Thank you. Ms. Gant, were you able to hear Ms. Francis just now?
Yes.
And was that an accurate recitation of the settlement agreement you've reached with her office?
Yes.
And you filed an answer with this court. They indicated you didn't know who LVNV funding was. Has Ms. Francis answered your questions regarding who the creditor is?
I'm sorry. Who the creditor is? She gave me a name and I have papers who the creditor is, but I didn't know them originally. What was the
But you
question?
know now.
Yes.
Okay. That being the case, the court will enter the consent judgment presented by the parties. Ms. Gant, I am adjourning the matter over to June the 4th at 9:45 a.m. So long as the consent judgment is submitted to the court, I will sign it and a copy will be mailed to you at the address we have on record. You will not need to appear on the 4th, but the court keeps that as a review date just so that the parties get the document signed and filed. So consent judgment will be submitted and signed. And if it's not for some reason signed and the parties don't have an agreement, you will return on June the 4th at 9:45, okay?
Okay, where do I go to sign this agreement?
Defendant did give us permission to sign the consent judgment.
Okay.
Is that true, Ms. Gant?
Yes.
Okay, then she will sign it on your behalf and file it with the court and you'll receive a copy.
Thank you, Judge.
Okay.
Thank you. Have a good day, ma'am.
Thank you.
This is, Ms. Gant, you could just exit out of that door to your left. What happened to her? This is 2302619 GC Collins Asset versus Amber Addington.
Good morning, Your Honor. Attorney Elizabeth Ellison, P82098 for the plaintiff.
This case was scheduled at 9:15. It's now 9:38 by the court's clock. Amber Addington. Defendant having failed to appear, ma'am, how would you like to proceed?
Your Honor, in light of the defendant's failure to appear, I would request an entry of a default judgment, Your Honor, for the sum certain amount of exactly what we pled in the complaint, which is $8,271.70. I'm showing costs of $186.78 plus a statutory $75 attorney fee. That brings the balance, Your Honor, to $8,533.48.
Please submit your default judgment through Unbase. Anything else this morning, ma'am?
Nothing further, Your Honor. Thank you.
Thank you. Have a good day.
You as well.
Thank you. 2302466 GC Occidental Development versus Dorel Blaga. Your appearances?
I'm sorry, Your Honor. Michael Dean, P81730 for the plaintiff, Occidental Development.
Sir?
Domnul Blaga?
Bună ziua!
Bună ziua! Dorina Costan mă numesc. O să fiu aici cu dumneavoastră să vă traduc ce spun domnii la tribunal.
Okay.
So, do you mind repeating that because Mr. Blaga was on mute?
I asked him to say his name.
Puteți să vă spuneți numele, vă rog.
My name is Dorel Blaga.
Numele.
Thank you. Mr. Dean, have you spoken to Mr. Blaga this morning?
No, I have not, Your Honor, but I would like the opportunity.
Thank you. Ms. Constant is in a breakout room on another matter. We'll move her back in and then we'll get you connected with she and Mr. Blaga, okay?
Yes, Your Honor.
Thank you. This is 2401857 GC Cade Enterprises versus Crystal Transport. May I have your appearances, please?
Your Honor, Patrick Arella appearing on behalf of the plaintiff in this matter, Cade Enterprises.
Morning, Your Honor. John Ivanchik on behalf of the defendant, Crystal Transport.
Thank you. Today's the day and time scheduled for the first pretrial in this matter. How are you proceeding, Mr. Arella?
Your Honor, we're asking for a 30-day adjournment. I think we're really close to a settlement here. We're just waiting on some information from the defendant.
June 4th is just inside of 30 days. Will that give you sufficient time to do what you need to do?
John, do you think so?
Yeah, I don't see why not. My guy's pretty getting documents.
June 4th at 9:30.
Thank you, Your Honor.
Back
Thank you,
here
Your
on
Honor.
Zoom. Is there anything else, Mr. Arella?
That's it, Your Honor. Thank you.
Anything else, Mr. Vanchik?
No, Your Honor. Thank you.
I'll see you on June 4th. You have a good day.
You too.
Thank you. This is 2400926 GC Transport Systems versus K&M Express. May I have your appearances, please?
Yes, good morning, Your Honor. Drew Norton on behalf of the plaintiff, Transport Systems.
Good morning, Your Honor. Issa Head on behalf of K&M Express.
Thank you. The case is scheduled this morning for hearing on the defense motion for summary disposition. The parties have had the chance to speak. Mr. Haddad, how are we proceeding this morning?
Judge, we are proceeding with our motion.
Please proceed, sir.
Your Honor, this motion, this case was first brought in Dearborn District Court. We filed a motion to transfer this to this court. That was stipulated to. When this court came here, the complaint had a one-count breach of contract. There's absolutely no connection with Transport Systems, the plaintiff, and then my defendant, K&M Express. K&M Broker, the co-defendant, has defaulted. They have a judgment against them. And KM Express has no ties, no signed agreements, nothing with the Transport Systems Company. Now, and that's the gist of our C8 motion and a C10 motion. Now, with regards to their allegations that this is double brokering, that there's, people are.
Mr. Haddad, I'm going to interrupt you for 1 second. Mr. Norton, my apologies. I asked him, was he ready to proceed with his motion? And I didn't ask you the same. Were you ready this morning on the motion?
Yes, Your Honor, for sure.
Thank you. I'm sorry, Mr. Haddad, you may resume.
Thank you. And so what the plaintiffs brought forward is a frivolous lawsuit against KM Express. They're an innocent party here. The brokerage company hired the Transport Systems Company to pick up some trucks from the same parking lot that KM Express and KM Brokerage work out of. They picked up 4 trucks. They delivered them to Texas. They came back. General Motors did not pay for those loads, and the brokerage company had went out of business. There's some claim for approximately $2 million that they didn't get, and Transport System is just one of the parties that fell in this mess. Now they're coming after KM Express with no signed agreements, no contracts, no anything that binds my client to these guys. Their 1 count of breach of contract doesn't include my client. We filed our motion. I did have an affidavit. I submitted that, and then when the case got transferred, there was nothing to file. And then when the case got reinstated, we submitted the affidavit with my reply showing that there's no ties to KM Express. And the plaintiff has filed a first amended complaint, a second amended complaint, all without leave from the court, all outside the time frame to file these things. And so we're asking you to grant our motion to dismiss with prejudice and make sure that, any chance they have to amend the complaint would be futile and just wouldn't be just. There's no new facts that would bring light that my clients, by their corporation or their individually or through their personal liabilities, would be liable to any of these damages.
Anything else, sir?
Nothing further at this time, Judge. If you got questions to ask me after, I'm ready to answer them.
Mr. Norton.
Thank you, Judge. To state that there's no connection amongst these parties is just a gross simplification and simply wrong. Before getting into the weeds of the merits, first of all, procedurally, this case has gone through a path that's highly irregular. It was filed in the 19th at Mr. Haddad's request to move it here. I agreed right off the get. The transition was anything but smooth. The transfer order fell in limbo somewhere. In fact, it was originally rejected by this court, it looks like. Sent back, came back. In response to his motion, I had a first amended complaint, which I filed as soon as I found out this court had the case, which they took, opened, and closed, and granted the motion without a hearing, without telling anybody. So, Judge, first, before getting into why there is contractual liability for KM Express, by the way, a company that has the same owners, the same address, the same principals, the same domain, the same everything, the 2 companies, one's conveniently out of business now. Before we get there, Judge, there's all sorts of big picture type principles here. Notice pleading in Michigan, liberal amendment rules, favoring decisions on the merits. There's absolutely no prejudice to the current defendant for this case to go forward. On the merits, 49 U.S.C. 14916 provides for liability for what they call co-brokering or double brokering. So this sister company, in fact, we picked up the loads from KM Express, even though it was brokered originally through a broker agreement with KM Brokerage. Again, same people using KM Express emails. But anyway, when we picked it up there, they became a shipper or a consignor. Under 49 U.S.C. 14916, that makes them a shipper. That puts them on the hook. And by the way, under subsection D, which includes anybody, quote, involved, a shipper, that makes them liable as well as the principals, which we've added in this second amended complaint, Judge, all which were filed. None of this was huge amounts of time. let me see here. So, Judge, I would just say for a number of reasons, both policy, procedural, and on the merits, this case should go forward here.
Anything else, Mr. Norton?
No, thank you, Judge.
Anything else, Mr. Haddad?
Yes, Judge. What I'd like to bring to the court's attention is all the numbers of exhibits filed in response, plaintiff's response to this here. There's bills of lading, stuff going to Flint, stuff going to Owasso. Nothing says K&M Express or K&M's broker. There's like 40 pages of exhibits that just, I don't understand what they are. I think it was just put in there to confuse the court. Yes, K&M Brokerage, K&M Express were two companies that were working together. But K&M Broker is the only one that has a contract with Transport Systems. And so no matter what they claim, what they say, there's no privity to bring in a non-party for liability for something that had not contracted with these guys whatsoever. All the attachments that they've attached to the motion for summary are not part of the complaint. When you look at it as a C8, when you look at it as a C10, none of those documents have signatures of my clients on there. And it's like they tried to confuse the court with what they're claiming. We're asking to grant our motion and deny them leave to amend their complaint to bring in other parties.
You may have 1 second, Judge, just real quickly. That's not true
Mr.
again.
Haddad, were you finished?
I was finished, Judge. Thank you.
Thank you. Mr. Norton?
Briefly, Judge, thank you. Sorry to interrupt. Again, that's not true. The carrier load tender agreement has the pickup at K&M Express on Wick Road, by the way, same address for both companies. Under the law I cited and in the industry, and I suspect, Judge, being where you sit, you get a fair amount of transport, a fair amount of motor carrier cases. The operative documents are the bill of lading and the load tender sheet, the rate con, they call it. And they clearly all say for these loads that it's picked up at K&M Express. And in the industry and under the law I've cited in my brief, that makes them a shipper, puts them on the hook. Thank you, Judge.
Anything else, Mr. Haddad?
Nothing further to add, Your Honor.
Thank you. The court has had the opportunity to review the file in its entirety, along with the defendant's motion for summary disposition. Don't wait, please. And the response, the court will deny the motion for summary disposition. Mr. Norton, you had in your response to the motion and this morning argued that this case granted the motion without hearing. That is not true. That was from the 19th District Court. The first time that this court saw the file was the first amended complaint and noted that leave had not been granted either in this court or in the 19th before the transfer for the complaint to be amended or for parties to be added. The court did receive the first and the second amended complaint. Mr. Haddad has made the argument that your amendments were untimely and that you did not have leave of the court. The court is granting leave for you to amend the complaint. I'm sorry. The court is considering your request to amend the complaint, but Mr. Haddad seems to have some objection to that. Is that something that we need to have an additional hearing on, Mr. Haddad?
No, Judge. I'm confused. So is the original my motion for summary was based on the first original complaint, and so you're denying that. But I'm not sure if you want to grant that and then grant them leave. I'm really confused on the logistics of where we're at now.
Exactly. And this court has gone through it because when the case was transferred, nothing happened. I don't know why it wasn't scheduled for either a pretrial or on the motion that you filed back in January, on January 11th. And so I'm trying to get this case untortured. So I'm denying your motion and then full stop, period. And then you have the issue of the amended complaints that were filed without leave of the court. And this court didn't think they were timely. And the case seems to have been a little bit jumbled because the transfer happened in 19 and then nothing happened in this court for over a month. So before I said anything about a response to the second amended complaint or the first amended complaint, I asked, is that something that needs to be motioned up given the transfer, did you want an opportunity to be heard on Mr. Norton's request to amend the complaint? I'm trying to procedurally get us back clear and on track.
No, Judge. If the court's going to allow his Second Amendment complaint to, I just asked for time to file a response to that. In the basis for the denial of my motions, is that you denied my motion for summary. Is that without prejudice? Do I have to refile that based on the Second Amendment complaint, or is it based on the merits? I'm not sure how the court's proceeding, because we have the same arguments against the Second Amendment complaint, that there's no privity, and these agents or companies have nothing to do with transport systems.
The denial of the motion is without prejudice, sir.
Thank you.
So that being said, and then in an effort to get this case back in proper procedural posture, how long would you need to respond to the second amended complaint?
I would ask for 14 days, Your Honor.
No objection.
So, Mr. Haddad, if you're able to get that answer filed within the next 14 days, do we need to come back for the first pretrial of this case?
Judge, my
On
intention
June the 4th?
My intention would be to file another motion for summary disposition based on the second amended complaint. And we have two additional parties, so a summons needs to be issued, and those individuals need to be served. And I can file on behalf of K&M Express, but there's also two additional individuals that no summons has been issued, and so that creates another dilemma for Mr. Norton.
You won't accept service for him?
Well, I've been hired by K&M Express, so I got to talk to them and see if I will accept service for him. I know the one employee is no longer working for him, so I know I can't accept service for her.
So
You can get a sense of what's going
two
on.
additional parties are added, which means that the civil department who is on, there will be summons that need to be issued for those additional parties and service made. So, and Mr. Haddad, if you're not committing to, and I understand why not, if you're not committing to accepting service for those persons would need to be served and have the opportunity to respond. I'm just trying to think of a return date.
Yeah, it seems to me about delay, Judge. If he shows up representing them in the end, I might be asking for something. This has been a lot of delay, actually, but Judge.
It's with a transfer case, that always adds a layer of complication to a proceeding, but.
Yeah, it sure does.
Let's think this.
I'm sorry.
Go ahead.
But I was just going to comment. If you look at the transfer order too, it actually bounced a little. It for some reason got rejected and then back. And there was confusion, I think, with the two companies with almost the same names, and one being defaulted in the 19th and the other one. So I understand, but I'll stop talking, Judge. Whatever date you set, we're good with.
I'm trying. So if Mr. Haddad needs 14 days to respond to the second amended complaint, and the civil department issues summons for the two added parties, and your office effectuates service on them, whether it's upon Mr. Haddad or someone else, I want to set the next date out far enough for you to conceivably effectuate service. I'm looking at, I hate to go out to July, but June 4th seems kind of fast with adding parties. July the 2nd at 10 a.m. for the pretrial. Mr. Haddad?
That'd be available by, that's by Zoom, Your Honor. I'm available.
Yes, that's by Zoom.
No problem here too, Judge.
And Mr. Norton, if you will prepare an order that puts everything into a singular moving forward, adding of the parties, service of the summons, 14 days for Mr. Haddad. The court staff will send out the notice regarding the July 2nd, 10 a.m. pretrial date. I'm trying to just get us back on track. And if something happens between now and July the 2nd, please reach out to court staff. Was there anything else, Mr. Haddad?
Nothing, is that July 2nd? Could we use that for a hearing date for the motion for summary as well as the pretrial?
Absolutely. Pretrial / MSD, and I'll put notes in for civil so that everything makes sense. Well, makes senses. Anything else, Mr. Norton?
Yeah, just for clarity, Judge, the 14 days to respond, I mean, so he won't have his motion really prepared if one of these parties evades service. I'm just wondering, I don't want to waste anybody's time. Is the 14 days make sense to make him file his motion then? Well, we need the time to respond to the summary disposition. I'm sorry, Judge.
I'm with you, Mr. Norton, but I was looking at the fact that if it's 14 days from today, his answer is due on the 21st. If he files a motion and gets it in the mail June 4th, we'll still be on track for that July 2nd date. And if for some reason it's not, if you reach out to the civil department, they'll let me know and we'll figure out if we need to move that July 2nd date back.
Very good, Judge.
Anything else, Mr. Haddad?
Nothing further.
Thank you. I'll see you on July 2nd.
Thank you, Judge.
Thank you. Ms. Francis, I'll be with you in just a second.
Okay. Thank you, Judge.
This afternoon is live because of small claims.
We have something like
that. Yeah. The 1 and 2 o'clock small claims cases. That I say at 1 and 2, but it's actually, if they're still going, there's a 1 o'clock, 1:30, and a 2 o'clock.
Okay.
Thank you.
So all three.
In theory. Thank you. This is a recall of 2302337 GC Crown. Hold on, I'm sorry. I was looking for the interpreter. I don't see that she's back out, Miss Francis.
Judge, that interpreter wasn't for this defendant. I believe they were for someone else.
Yeah.
That being the case, have you had a chance to speak to Ms. Rosu?
I did, Your Honor. We did come to an agreement. We've
In terms
agreed
of that
to
agreement.
We've agreed to a consent judgment. The damages are $1,549.05, costs of $132.09, plus a $75 statutory attorney fee for the total of $1,756.14. Ms. Rosu will pay $150 beginning June 1st. And by the 1st of each month until it's paid in full, and she is giving plaintiff permission to sign the consent judgment, Your Honor.
Ma'am, were you able to hear the attorney just now?
Yes.
And it is your agreement this morning that you'll enter a consent judgment with a total due of $1,756.14, and that you'll make payments of $150 per month beginning June 1st.
Yes.
Then Ms. Francis' office will prepare a consent judgment with those terms, file it with the court. Court will sign it and mail copies to you at the address we have on record. If for some reason that consent judgment is not filed, the court is adjourning the pretrial to June the 4th at 9:45 a.m. Ma'am, so long as the consent judgment is signed and entered, you will not need to appear. That June 4th, 9:45 is more of a control date to make sure that the paperwork does get filed or that this case continues to move forward. Was there anything else, Ms. Francis?
Oh, Your Honor, thank you.
Anything else, Ms. Rosu?
No, that's all. So I need to I need to have another day of court, or I didn't understand exactly.
No. As
Okay.
long as Ms. Francis' office gets the consent judgment filed, you don't need to appear.
Oh,
And you'll know
okay.
that because you'll receive you'll receive a copy with my signature. And you don't need to
Okay.
return. That's just more of a control date to make sure the paperwork gets filed.
Okay. Thank you.
Thank you, ma'am. Have a good day.
Thank you, Judge.
Thanks.
Have a good day.
You too, ma'am. Thank you. This is 2301213 GC Preferred Medical versus Auto Club Insurance. May I have your appearances, please? I know I saw Mr. Sakala. Ms. Medina, were you ready? This is 13. Mr. Cox, this is your case. I just received a note from the Civil Department that this case was scheduled this morning. It did not appear on my docket. If you give me one moment. This is 132014 GC. This is Auto Owner Insurance versus Skinner. May I have your appearances, please?
Good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
Kalila Dean.
Thank you. Today is the day and time scheduled for hearing on the defendant's objection to garnishment. Have the parties had the opportunity to speak?
Yes, Your Honor.
Was there any agreement, Mr. Cox?
No, Your Honor.
Thank you. Ma'am, what is your objection to the garnishment?
Well, my objection was for future garnishments, and from my understanding, I am preparing myself for bankruptcy. I had already retained my attorney, and I explained to the counselor, Mr. Cox, that my purpose of the objection was to stop any future garnishments because I retained a bankruptcy attorney. But I guess I move a little bit too fast, and it's my understanding that that can be done until he technically filed it, but which I do plan on doing within this month. My attorney is paid in full. I had to shut down our business, and I was just trying to prevent from any future garnishments of my state taxes.
I think that's right, Judge. We discussed the matter in the breakout room, and I called her bankruptcy attorney. She's not filed yet. I think the basis for objections were going to be that the garnishment was not allowed by the bankruptcy filing, but she hasn't filed yet.
Thank you. Ma'am, that being the case, your objection to garnishment will be deemed invalid and denied. Once you actually file, your bankruptcy attorney will file the proper notification with the court so that the court may stay any additional proceedings, okay?
Yes, ma'am. Thanks, Your Honor.
Anything else, ma'am?
No, ma'am.
Anything else, Mr. Cox?
Only that I'm here on a 1015 matter, Pickwick Park versus Beasley, and I'll just wait for that case to be called.
I will see you at 10:15. Thank you, Mr. Cox. Ma'am, you're
Very
free
good.
to go.
Thank
You have a great day.
You have a better one. Bye-bye.
Thank you. We're back on the record in 2302466, Occidental versus Blaga.
Thank you, Your Honor. We were not able to come to an agreement. Therefore, we respectfully request that the court issue a standard scheduling order, 60 days of discovery.
Ms. Costin, if you want to relay that information.
Yeah, I just don't see Mr. Blaga. Sunteți
I
acolo,
see
Mr.
him.
Blaga?
Da, I'm here. I'm here.
Ok, so ați înțeles ce a spus. Domnul Din a spus că nu ați ajuns la un consent și el cere ca să fie deschis un caz la tribunal din pricina asta. Aveți de spus ceva?
Nu, am nimic, aș întreba judecătorul dacă este o fraudă să cheșești un cec fără semnătura mea și cum au ajuns în posesia lor, atât. Și dacă după 7 ani de zile vine ei să caute dreptatea.
So Mr. Blaga states that that check that was cashed from his account is a fraudulent activity. He would like to know if you would agree, Judge, with a case like this when he was owing $420 and he had a check taken from his house and cashed by those people that he was actually owing that money, the $420. What would you say in this case? Would you agree that was something that people should do? And he would have to go back 7 years to prove that this fraudulent activity happened, and he would open a case against them.
Îmi trebuie puțin timp să mă duc la bancă și trebuie să-mi caut dosarul și că 7 ani, nu eu, să caut din urmă.
So he would
The
go to
court
the
does
bank.
not know what $400 check he's referring to.
So he stated earlier that during that time when he was living in that apartment, some people, he thinks the management or people that were working on fixing his air conditioning took a check that it wasn't signed by him and cashed it to the bank. So he doesn't think he owns more than $420 because he had $500 deposit, and the $420 would be the difference between $920 and $500 that he had deposit. He only owned a month of rent.
The attorney has requested 60 days discovery. The court will grant 45 days of discovery. Set your return date of July the 2nd at 9:15 a.m. for the adjourned pretrial.
So, domnul Din a cerut 60 de zile discovery, deci o perioadă în care să se pună la punct cu un caz și judecătoarea a acordat 45 de zile și dumneavoastră va trebui să vă prezentați în cort în iulie 2 la ora 9:15 dimineața.
Okay, I understand.
Anything else, Mr. Dean?
Yes, Your Honor. Is that going to be remote?
Unless you want to be in person, yes, sir.
I appreciate it. Thank you, Your Honor.
Thank you.
Anything else, Mr. Blaga?
Domnul Blaga, acea întâlnire va fi iarăși virtuală?
Dacă am o întrebare?
Nu, eu am vrut să vă spun că întâlnirea în cort în iulie 2 o să fie și aia virtuală, nu în persoană.
Deci tot pe Zoom?
Da, presupun că da, tot pe Zoom.
Ok.
O să întreb, da, o să vă spun și să întreb. Nu s-a menționat aia. Would that be a Zoom meeting?
Yes, ma'am.
Da, tot o să fie pe Zoom. Sunteți de acord cu asta?
Sunt de acord, dar e prea puțin timp pentru că eu atâta vreau să întreb pe doamna judecător, dacă am dreptul să o întreb, dacă un cec îl cheșește cineva și unde am stat eu în chirie, au ajuns în posesia lor și l-a cheșuit. Vreau să știu dacă este o fraudă sau nu.
So he has a question for you, Your Honor. He would ask you if you think that cashing somebody else's check without his signature, would you consider being a fraudulent activity or not?
That's not before the court this morning. Thank you.
Nu despre asta sunteți aici astăzi.
Păi eu am ajuns, dar după 7 ani de zile, dacă după 7 ani de zile m-au dat, păi și eu trebuie să-mi spun off-ul. Pentru că pe nu mă face așa 2400 care ciură, că puteam să-i trimit, dar consider că am fost nedreptățit.
He thinks he's being treated unfairly, and that's why he's asking this question. So it's not about the money, it's about the principle behind it, because he was treated unfairly.
Și îmi trebuie mai mult de 45 de zile, pentru că eu sunt pe drum, lucrez, eu ajung peste 2 săptămâni acasă, trebuie să mă duc pe la bancă, trebuie să-mi iau tranzactor. E foarte mult, adică de umblată. 7 ani în urmă, 7 years old.
He needs more than 45 days because that is a lot he has to put together, and he does not have the time being on the road all the time.
The court has made its ruling, and that concludes this case. Have a good day.
Judecătoarea spune că nu există termen de negociere aici, ea așa a stabilit și să aveți o zi bună.
Okay.
Thank you.
Thank you, Your
This
Honor.
is 2301213 GC Preferred Medical versus Auto Club Insurance.
Your Honor, Freddie Sackler appearing on behalf of you.
Morning, Honor, Matthew Cohen on behalf of Defendant Auto Club.
Good morning. Have you spoken this morning?
We have,
Your Honor.
How are we proceeding, Mr. Sakla?
Your Honor, we're moving forward. There's nothing, we're far apart on numbers, Judge.
Mr. Cohen?
I would agree with that, Your Honor.
Thank you. Please proceed.
Okay. Your Honor, it's a simple case, really. We filed it. We filed it when we weren't being paid our full balances. Sometimes we were being paid 20%, 30%, 50%, sometimes 0% in invoices, nothing was paid. Ultimately, Judge, what we have to prove is just the following things. One, we have to prove that the defendant is a carrier. We have. It's unadmitted. It's admitted. We have to prove that Mr. Olmstead is entitled to benefits. We have. Mr. Olmstead has been receiving benefits since 2003, 21 years. We have to prove that transportation services are covered under the statute. The case law and the statute are clear. We have to prove that we perform those services. There's no one in dispute. They've partially paid us on all these services. The case that we attached in our reply brief and we cited in our response, in common sense, when you're paying for the services and you're only disputing partial payment, you can't later go back and say, well, hey, we paid you and we've been paying you, but we believe that he's not entitled to services. That's unreasonable. Moving forward, Judge, our job is to bill them. We have. The case law is clear. Even though our invoices and our bills actually do put CPT codes and those other types of things, we don't do Medicare and medical. We're a private transportation provider. We're actually a very niched. We only do brain injuries, and we've been doing this for many years. And ultimately, Judge, we have a very set fee that we charge all carriers for the exact same thing. And we bill accordingly for that. They received our bills. We acknowledge that by making payments on them, and they send us back what they decided to pay on each particular line item. So the only question left is, are fees reasonable, or does the defendant offer any evidence to show they're not reasonable? Now, our affidavit, our original motion, clearly articulates that Ms. Amick, the owner of this company, who's been doing this for years, looked at the geographic market, determined her fees, determined her price, and ultimately charged her fees and price, and that they're reasonable. She's an expert in the industry. She's been in the industry many years. She has an affidavit. She attached it. In addition to that, when we got a reply that says, hey, your affidavit doesn't give enough documents, even though our affidavit is testimony, we said, well, we gave you an answers to request to produce documents, and now we're attaching to this motion in our reply our specific carriers, 6 of them, that paid hundreds of line items for the actual rates that we're charging AAA here. And none of those carriers have disputed it, and they're all paying it. The Exhibit 1 of our reply is the actual support of the statements in the affidavit that we are paid these fees in 2023 that we are charging to this defendant. More importantly, Judge, they argue in their reply, in their response, that we're not entitled to attorney fees. And I'll tell you 2 things. First, we're entitled to attorney fees because, one, if you have a problem with our fees, then write us a letter and say your fees are not reasonable because of this. The statute says that we're entitled to attorney fees, that there's the that 30 days after an insurer receives reasonable proof of the fact and the amount of loss sustained. It doesn't say anything about the fees. So they've got to pay us if they think that there's a problem with the facts or the fact and the amount of loss sustained. In our particular situation, they didn't write a letter and say, hey, we're going to lower your bills and we're going to pay you less because of this. They didn't explain that the market price is $42 and you're charging $55, and here's our proof. They just ultimately reduced our fees. And then if you look at our Exhibit 4 of our reply, they just flat out didn't pay things to zero. So some months they're paying, some months they're giving us zero. How does that logic? More importantly, we filed a case. We get all the way to the end where we're at today. They attach a response to the motion for summary, and all they attach is our answers to our request to produce. They offer nothing in the way of their own affidavit, their own testimony, their own analysis as to why our fees are not reasonable. Judge, you're familiar with this all the time. I don't do NOFA all the time. So I guess I'm a little bit more boisterous on this stuff because everyone just accepts it. I have 1 or 2 clients now that I'm handling this for, but you know, you can't just deny because you want to work a deal later. That's not how this works. And luckily, this is not an insured who can't afford to fight for their medical benefits. This is an insured who is assigned to us. We go out of pocket, but we're able to actually fight the insured. So $16,000, the amount, Judge, there's no statute of limitations argument. We filed on 9/7 of 23. Our invoices go back from 9/16 of 22 to 10/1 of 23. The balance owed is $16,590.60. Interest is $1,000. $1,017. And we'd ask for a hearing on attorney fees if the court thinks that's necessary. The interest amount.
$163.63.
Interest amount is $113.52. Our reply was better calculated, Judge. Our original motion. Off. Thank you, Your Honor.
Thank you. Your response.
Your Honor. I'm going to stress that this is a motion under C10, which requires the plaintiff or the moving party to bring forth documentary evidence substantiating all of their claims. And here we have a twofold argument. One, that all of these services are medically necessary. And the second one is that the charges are all reasonable, 100% of them. So then I have to break this down into 2 arguments then myself. Plaintiff actually did a pretty fair job of going through what they have to prove. The problem is that they have no documentary evidence to support any of it, especially with regards to the medical necessity of the services allegedly rendered. To start, Your Honor, plaintiff takes the position that the Michigan Institute case, an unpublished case, stands for the position that a payment made by the insurer effectively deems them responsible and liable for these payments and medically necessary for these charges. That simply isn't what the Michigan Institute case says. It says that a payment made by an insurer is evidence that it was incurred, but incurred is not medically necessary. Those are 2 very distinct positions under 531.07. But more importantly, as I cited to in my response, and what plaintiff apparently refuses to acknowledge, is that both the Hammermeister case and the Calhoun case are published cases. They state very clearly and unequivocally that just because an insurer makes a payment does not mean that they cannot later dispute whether or not they should have made that payment. Again, those are 2 published cases that, as far as I'm aware, have never been overturned. And as far as I'm aware, that Michigan Institute case never cites to because it's not applicable. That was a case regarding services being incurred by the claimant. That's with regards to the partial payments that my client made. So no, there is no concession and there is no argument under that case that these were medically necessary services despite the payments. As to the things that were not paid, again, this is a C-10 motion. It is plaintiff's burden to prove that these services were medically necessary, irrespective of whether they were paid or not. What plaintiff attached were 2 documents. Those documents were signed by, I believe it's their Exhibit 2 to their initial motion. Those documents were signed by a doctor. Nowhere in either of those documents does it say that the services are related to an accident. Nowhere does it even mention an accident occurred. The closest that plaintiff gets to an argument of medical necessity is that it says a TBI. Plaintiff cannot testify as to what the medical situation is with this individual. They don't attach anything to assess what the situation is, other than these 2 documents that, again, make no reference to a motor vehicle accident whatsoever. And so for that reason, plaintiff has not satisfied its burden under C-10. With regards to what they have provided as medical necessity of these services, plaintiff does not attach a single document to this court showing where the transportation was. They don't show a single document as to the dates of service. They don't show a single document as to the addresses. All they show is a ledger. That ledger only lists what the ledger date was authored. It shows, I think, the 1st of every month and the 16th of every month. This court, nor myself, have any idea what any of these dates of service are, regardless of the payments. Plaintiff, actually, one of the most concerning things about this is that plaintiff talks about non-payments. So I went through. Plaintiff supplied 250 pages, I think just under 250 pages of discovery in February of 2024. They list in their reply brief 4 invoices, not dates, just to be clear, not dates of service, 4 invoices that were unpaid. I cannot find those anywhere in what they submitted as 250 pages. There's not a single invoice that I can find from 7/1/2023, from 9/1/2023, from 9/16/2023, and from 10/1/2023. And strangely, or maybe conveniently, those are the very invoices that plaintiff claims were unpaid. This is February 2024 that they supplied these documents to me as part of answers to discovery. These arguably invoices were probably submitted or done months and months and months ago. So why do I not have them? And it makes it incredibly difficult for me to talk to my client about invoices that I don't have and that they can't find because the dates of service aren't in these ledgers. It is just ledgers. So for that reason, under C-10, plaintiff cannot prove.
Are you almost done printing?
I'm sorry, Your Honor.
That was someone else. My apologies, sir.
So that's okay, Your Honor. So for that reason, if I can't tell you what these dates of service are and plaintiff can't tell you what these dates of service are because all they've submitted are ledgers, they have not proven the medical necessity because I don't know and this court doesn't know where they were transporting this individual. Plaintiff jokes, I think in the reply brief that, well, we were taking him to the movies. Were they? Because I can't say whether or not they were, and this court can't because plaintiff didn't provide any of that. So if this court is inclined to grant plaintiff's motion, before it does, I would ask for an evidentiary hearing to bring Ms. Amick in to determine whether or not she supplied these invoices to my client, when she supplied these invoices to my client, and exactly what she supplied to my client, because I can't make a determination in that regard. So for my last argument in regards to the reasonableness of the charges, there's 3 different positions that plaintiff takes in their answers to discovery, which I do provide to this court. They talk about a billing program. Okay. They also mention in the answers to discovery that the plaintiffs or the CEO set the rates. I asked how these rates were set, and they provide no actual answer other than possibly a billing program. Then I get this motion in, and there's an affidavit that states that, well, Ms. Amick looked at the general area. And instead of providing information as to who she talked to, when she talked to them, what information she got from them, plaintiff merely doubles down and says, because this is an affidavit, it means that it's a document, and under C-10, I satisfy that. Well, so the problem now, Judge, is that there is an obligation for plaintiff to bring forth particular facts when it comes to supplying an affidavit before this court. 2.119B1 states, if an affidavit is filed in support of or in opposition to a motion, it must A, be made with personal knowledge, B, state with particularity facts admissible as evidence establishing or denying the grounds stated in the motion. I'm going to stop there. There is absolutely nothing in this affidavit that states with particularity that the facts that are admissible. Ms. Amick merely says, I called people in the area, I got this information, and that's what makes this reasonable. No names of providers, no individuals she talked to, and certainly no rates that were discussed in this conversation. So under 2.119, this affidavit lacks the appropriate form to be deemed admissible evidence under a C-10 motion. They then talk about the payments that were made by other insurers. First and foremost, that is hearsay. Insurers pay different claims for different reasons. But more significantly than that, as plaintiff counsel has alluded to, this company has been in business for a long time. Presumably, they have more than 6 entities that they bill. This is the very definition of cherry-picked evidence. So again, like I asked with my evidentiary hearing in regards to whether or not these claims were submitted, I think this court should know what other insurers are they billing and what amounts are those insurers paying? Because I'm willing to bet, based upon my experience handling a lot of different carriers, that these are just the 6 that are paying at 100%, and there are plenty more that are being billed that pay a lot less. So if that is, in fact, what plaintiff is going to rely upon instead of the geographic region, then I do believe this court and my client is entitled to know what other carriers are ultimately paying and why it's determined that 100% from these 6 insurers should be noted and all the other payments from all these other insurers should be disregarded.
Anything else, sir?
No, thank you, Your Honor.
Anything else,
Yeah.
Mr. Sakala?
Yes, Judge. I think okay, first of all, attached to our discoveries, the 250 pages we provided counsel, was every invoice for every month. And I would direct, does the court have our reply on its computer screen by any chance?
I do not.
Okay, so Exhibit 4 of our reply is a specific check. The last page of Exhibit 4, counsel says his client never received our invoices. It's such a ludicrous argument, Your Honor, because the last page of Exhibit 4 is a check from his client. And at the top of the document, which is generated by his client, says the service dates of the actual work. And at the bottom is a check dated for 2024. I'm going to show it to the screen, to the court.
Wait, I'm trying to get to that last page of your Exhibit 4. Give me 1 second.
Thank you, Your Honor.
Last page of Exhibit 4 is a check that ends in S38 or 538.
Check that ends at check number 47. Yeah, 5528.
Excuse me, how y'all doing? Definitely need to see you when you're up.
Judge.
Yes.
Sorry, I'm in another court. Do you see that check, Judge? It's in the amount of $1,271.
I am looking at it, sir.
Okay, if you look at the top, this is AAA sending us, that's a check from AAA paying my client. If you look at the top, it says dates of service 6/20/23 to 7/27/23.
Excuse me.
I see it, Mr. Sakala.
Your Honor, that document itself actually clearly shows that they received our invoices in 2023 and that which we mailed to them every month, and that they didn't issue a check till 4/2/24, 8 months after I filed this lawsuit, because they started going through their stuff and realizing, whoa, we have 0 payments. So counsel's argument that they didn't make payments, that they didn't get invoices, is just a ludicrous argument. Counsel's smoke about the affidavit is smoke. If you've got the burden on a motion for summary disposition, Judge, is, and in the court well aware, but I'll read it, is to present a motion for summary disposition, the moving party has the initial burden of supporting its proposition by affidavits, depositions, admissions, or other documents evidence. The burden then shifts to the opposing party to establish that the genuine issue of fact exists. That's Corbell versus Comerica Bank, Judge. That's a Supreme Court decision. They don't get to just, we present facts and evidence, and then counsel makes his zealous attempt to make an argument when he himself can't testify. He has to provide exhibits, documents, testimony from AAA. He has to provide experts. He has to provide another contradictory affidavit. Counsel can't just get up here and say, well, we didn't get the invoices, and then moving forward. Example. Counsel says we don't support that the person has a problem, or we didn't establish, look at our exhibits to our motion. Our exhibits to our initial motion, Exhibit 2, is a prescription signed by a doctor that said, it's not a document, it's a prescription signed by a document for services. Exhibit 3 is an assignment of those benefits. Exhibit 4 is our summary of our invoices. We didn't attach every invoice, but every invoice, Judge, outlines in detail the actual billing items, and counsel as well has been provided that in our answers to discovery. So all I would say, Your Honor, is there's a reason there's no documents attached to their motion for summary and no affidavits in attached to the response to our motion.
Your Honor, I would like to respond very briefly.
Wait, I'm
to
sorry,
that.
before you say anything, give me just one moment. 240395 FY State of Michigan versus Eric Johnson.
Crystal Marie Medina, Your Honor, on behalf of Mr. Johnson, with regard to the arraignment, we would waive formal reading and stand mute, Your Honor.
Mr. Johnson, have this officer unmute you and state your name for the record.
Sorry, Your Honor. Eric Johnson, ma'am.
Thank you, Mr. Johnson. The court is in receipt of information that indicates that this case should have been dismissed. There was a plea in another case, and this court has received information that the CTN 822-372-4959-01 is to be dismissed. That is this case, the 240395 FY. So this case is hereby dismissed. Anything else, Ms. Medina?
No, Your Honor, thank you. That makes sense because he took a plea recently, and this is back in November. So thank you so much. I appreciate it. Thank you.
Have a good day. We'll get the paperwork over for Mr. Johnson. Thank you, Romulus.
Thank you, Your Honor.
Thank you, and thank you, Judge Martin, for squeezing us in.
Thank you. My apologies, sir. Your response to Mr. Sakla was?
That's okay, Your Honor. I will just ask, again, the same questions I've been asking. Mr. Sakla points to this check. And again, what invoice does this apply to? It says the dates of service, 6/20/2023 to 7/27/2023, I believe, or 7/17. But again, what dates of service and which invoice does it apply to? Because there are 4 different invoices he points to that are unpaid. I don't know what invoice this applies to. It doesn't say on this check. This court doesn't know. Mr. Sakla didn't say what check it applies to. He's asking for every single date of service to be deemed as medically necessary and reasonable. And he can't actually tell this court what dates of service these apply to, what invoice it applies to. And once again, Your Honor, I am more than happy to come down to the court and provide this, Your Honor, with all 250 pages of the discovery responses, so the court can take a look at every single page to know that I am not lying when I say I don't have these invoices. And what this is, I still can't tell you.
Anything else, sir?
No, Your Honor, I appreciate the time.
Thank you. Anything else, Mr. Sakla?
Your Honor, only that look at the beginning of Exhibit 4. It's another check with another document where the check is for 4 or 5 different invoices for dates for August, September, and October. All I can tell you, Judge, is if as an officer of the court, is he's going to represent that his client never received invoices from my client outlining every particular item of billing, then I would be glad to come to the court and show the court those invoices and show the EEOBs the explanations that were sent back with the payments in every check we got for every one of those months. Council wants this court to believe somehow we got checks every month and we didn't, and AAA just decided to give them to us like it was a gift. So I cannot, I appreciate council's attempt to clear and distort the lines here, but there is nothing unclear about this case. Thank you, Judge.
Thank you, sir. The court, having had the opportunity to hear from the attorneys this morning and reviewing the motion that was filed, the response and the reply to the response, the court is denying the motion for summary disposition that was filed pursuant to C-10. I know that there was a jury demand made in this case. And we were last here, I think that our conversation was, we would determine a jury trial date after any motion hearing if it were necessary. Is there any possibility that the parties are able to reach an agreement, or is there some settlement conference that might be had, or some other way to move forward in this matter?
Your Honor, we've offered a large discount on the balance. We ignored interest, attorney fees. We reduced our principal balance to, I think we sent an email with was about a 15% discount. At this point, going this far in litigation, I'd ask the court just to set us a trial date as soon as the court can get one, and let's try this case.
And I'll respond and say my client's more than willing to negotiate. We have been talking about what we can do. This is an MCCA file, so we have a bit of that as a hang up, but my client was happy to start talking numbers, and all of a sudden we get a motion for summary disposition, and that kind of puts the kibosh on that. Obviously, if plaintiff's entitled to take this case to trial if they want to. I can assure you that my client's open to negotiations, but at this point, if they're gonna, stick their head in the sand and say, we don't care what you have to say, then I guess a trial date is what we need then.
Counsel can give me a number, Judge, whenever he likes. And if you'd like to email me a number, I can respond to it. I'm never saying I'm not open for negotiations. I'm just saying that delaying these cases only costs more and more money on everybody's part and eats up more and more attorney fees. So, I mean, it takes a day to go get approval from his client. And till today's date, he's never given me even a number.
Yeah, as I mentioned, the MCCA is involved in this. It doesn't just take a day. It's a process.
I'm looking at sometime during the last week of June as a jury trial date. Would you gentlemen check your schedules for me, please? Marianne, what's scheduled that week, please?
That'd be the week of the 24th, Your Honor?
Yes, sir.
Would it trial start on I'm sorry, I didn't mean to interrupt your clerk.
Judge, you have felonies on Wednesday and you have your ordinance on Thursday.
So we'd be looking at the 24th, 25th, or 28th?
Correct.
Were you starting to say something, sir?
I was going to ask what day of the week, and I think you're about to answer it, Judge, so I apologize.
No, no worries. I was looking at Monday, Tuesday, or Friday, the 24th, the 25th, or the 28th.
The 24th that Monday would probably work best for me, Your Honor.
Mr. Sakla? Uh-oh. Sir? He appears to be frozen.
Counsel, I'm willing to waive jury.
He said he's willing to waive jury.
I assume that he was willing to waive the jury demand, but I think that that was our jury demand, and I doubt that I'd have to talk to my client, Your Honor. If assuming that's what he said, I can't say yes or no to that right now.
So let's do this. If it looks like we've lost him. If he logs back on, I'm looking at June the 24th at 9 a.m. And we would set June the 3rd as the filing deadline for witness, exhibit, and proposed jury instructions. If the two of you speak in the interim and your client allows you to waive the jury demand, just communicate that to Mary Ann or the civil department. And we'll follow up with him. I have Mary Ann or a civil department follow up with him. If you need to come in, if you need to be seen or heard before that June 24th date, let someone know, let the civil department know, or let Mary Ann know. And when he logs on, I'll relay the same information to him.
I appreciate that. And I'm sorry, Your Honor, the witness list, what was that date again?
June 3rd.
Oh,
That's
okay.
just the deadline to file witness, exhibit, and proposed jury instructions.
Okay, all right. Yes, thank you very much, Your Honor. And I can always send him an email too with the dates as well if he doesn't by chance pop on.
I appreciate that. Thank you, sir.
All right, thank you, Your Honor.
Have a good day. Oh, wait.
You too.
Here he is. Mr. Sakla? His audio is not connected. If you want to wait around and maybe go into a breakout room with him, unless you're rushing off somewhere else.
I got nowhere to be, Your Honor. Not at least till this afternoon. So I can wait around. That's fine.
He's
Thank
gone.
you.
He's gone now.
Oh,
He's
I
gone.
can send him. Do you want me to send him an email, Your Honor, with this, with the dates?
Would you please? And I'll have civil department follow up with him as well.
No, not a problem, Your Honor. Thank you.
Thank you. 2302877 GC 21st Mortgage Corporation versus Forrester and Forrester. This case was scheduled at 9:45 on plaintiff's request for an execution. The court has received an ex parte order asking that the judgment that was previously entered be vacated and the case be dismissed without prejudice. Neither party has appeared. That order will be signed. This is 2400455 GC. This is State Auto Insurance versus Romulus Auto Group. May I have your appearances, please?
Good morning, Your Honor. Attorney Josh Hadley, appearing on behalf of the defendant Romulus Auto Group. I see co-counsels here as well.
Good morning, Your Honor.
Tiffany. Sorry.
No problem. Good morning, Your Honor. Tiffany Palmer on behalf of plaintiff, P number 74809 for the record.
Thank you. When we were last here on April the 16th, the parties notified the court that a settlement would be filed within the next 14 days. The court has not received anything unless it was filed this morning. How are we proceeding, Ms. Palmer?
Your Honor, the case is still resolved. We are just, we got the release over to them this morning. So I anticipate that we would have the dismissal within 2 weeks of today, if not shorter, Your Honor. But we're coming to a close on this.
I concur with everything that Ms. Palmer said.
Thank you. I'll make a note in the file that we are expecting a settlement document within the next 14 days. Anything else, Ms. Palmer?
No, Your Honor.
Anything else, Mr. Hadley?
No, Your Honor.
Thank you. Have a good day. Mr. Sakla?
Yeah, Judge, I'm so sorry. I'm at the 36th District Court and I was in a courtroom and the court officers didn't want me in that area. So they made me move and then my signal fell.
No worries. I saw you in the stairwell. You will be getting an email from brother counsel, but what we agreed to, if your schedule allows, is a jury trial on June the 24th at 9 a.m. He is reaching out to his client regarding your waiver of the jury, and he will notify you and the court if his client is authorizing the waiver. But for right now, we'll set it as a jury trial. Witness exhibit list and proposed jury instructions are due on June the 3rd.
Excellent.
And should you need to come before this court on any matter before that June the 24th date, please reach out to either Sandy in the Civil Department or my secretary, Mary Ann, and we'll get you scheduled to be seen and heard, okay?
Thank you, Your Honor.
You're welcome, sir.
June
Good luck in
24th.
36.
Thank you, Judge.
This is 2400518GZ. Papazine versus J&M Towing and Romulus Police Department. May I have your appearances, please?
Yes, good morning, Your Honor. This is Edward Nykel, P42017, on behalf of Paul Papazian and his companies.
This is Alexander Bloom on behalf of J&M Towing.
Good morning, Your Honor. Tom DiPietro, appearing specially pursuant to an invitation from this court to participate in this action. I have since learned in the breakout room that my client has no direct action against him, but we are all interested in settling this case. I am hesitant to enter a general appearance because I don't know what I'm getting into exactly. And don't have the consent of my client to do it right now. But if I may continue, Your Honor, what we discussed is the three of us getting together. We have counsel now for J&M Towing. Mr. Blum is here, and he's going to update his invoices for us. And then we're going to squeeze Mr. Nykel to come up with a demand. And then Mr. Blum and I are going to squeeze our clients to come up with some money. That's basically where we're at.
I think
Mr.
that
Nykel?
is accurate. We're looking for perhaps, I don't know what the court schedule would look like to maybe continue this matter to a date, perhaps 3 to 4 weeks into the future. Give us some time to discuss, negotiate, hopefully resolve the matter.
June 4th at 11 a.m.
That's 4 weeks. That would
Okay.
for me.
Is that good for you, Mr. Bloom?
Yes, that works.
You said 11, Your
Mr.
Honor,
DiPietro? I
Yes,
did,
Your
sir.
Honor. Yes, Your Honor.
and that's good for me
Mr.
as well.
Nykel?
Yes, ma'am.
Thank you. That's the only thing that'll be scheduled at 11 a.m. So if something happens between now and then and you reach an agreement, please let Sandy in the Civil Department know sooner rather than later, okay?
Very well, Your Honor.
Will do.
Anything else, Mr. Nykel?
That is all. Thank you, Your Honor.
Anything else, Mr. Bloom?
No, thank you, Your Honor.
Anything else, Mr. DiPietro?
No, Your Honor. Thanks.
Thank you. Have a good day, Mr. Sams. Good to see you again. Have a good day.
You too. See you in
Thank
4
you.
weeks, Your Honor. Bye-bye.
This is
Your Honor?
24018. Yes.
I'm wondering if Mr. Richard Williams can be put back in a breakout room with myself and Mr. Beasley. He is the garnishee defendant in the case. And
Thank you.
that would be helpful. Thank you.
We'll get him moved back in with you. This is 2401849 GC Barclays Bank versus Michael Modelski. This case was scheduled for a pretrial at 10 a.m. It's now 10:52 by the court's clock. Defendant has failed, or parties have failed to appear. I'll double check the on base and the ROA, and if there's no explanation for the failure to appear, the case will be dismissed. Mary Ann, I'm taking the briefest of recesses. Well, recess, stepping off momentarily. Let's say it better.
Mary Ann?
Yes, hi, Sandy.
Hi. Do you have that case number Judge was just talking about? I don't have it on my docket.
You know what I was, wait, let me see. Yeah, the one that the failed to appear, 2401849.
That one was, we received a conditional dismissal on.
Okay,
So,
Thank
yeah. Okay, thank you.
So yes, Sandy, today's on-base notes are going to be very interesting. What happened? Oh, so you already know. It's always something. Sure. I've seen a small whole camera whole car video system. Relatively cheap. I'm thinking about it. Are we ready on 023484 GC Brookline versus Lane process?
Yes.
Your appearances, please.
Joseph Beasley. Hi, Richard Williams.
Judge, good morning. This is Attorney Keith Cox for the plaintiff.
Good morning, Mr. Cox. The parties have had the opportunity to speak. How are we proceeding this morning?
Well, Your Honor, this was plaintiff's motion in an attempt to default the garnishee defendant for its failure to disclose pursuant to the being served a writ of garnishment. Mr. Williams is appearing today on behalf of the garnishee defendant. On that basis, we've exchanged information, my email to him and his email to me, and we're going to get him a disclosure form to complete and send back to us. On that basis, I'm requesting the court grant us either 2-week or 1-month adjournment, because I think the matter will resolve by way of the disclosure that we've been seeking now that we have the garnishee defendant's full attention.
Mr. Williams, will 2 weeks give you sufficient time to get the disclosure into Mr. Cox's office and adjourn with the adjournment of this matter?
Yes, 2 weeks is good.
Mr. Cox, I'm looking at May the 21st at 9:15.
That date works for the plaintiff, Your Honor.
Mr. Beasley and Mr. Williams.
Yes, Your Honor.
We're adjourning this matter over to May the 21st at 9:15 a.m. It will be back on Zoom. And if you would get that disclosure completed and over to Mr. Cox's office as soon as possible.
And Mr. Williams, I'll be emailing that disclosure to you sometime today, so you keep an eye out for it. And if for some reason it doesn't come your way, please reach back out to me and let me know that you haven't got it.
Yes. Will do.
Anything else, Mr. Cox?
No, Your Honor. Appreciate the court's patience.
Anything else, Mr. Williams?
No.
Thank you. You all have a wonderful day.
You too. Thanks, Judge.
This is 150974 GC. This is Razor Capital versus Edward Sumler.
Your Honor, Edward Sumler.
State your name for me, please. Oh, thank you, Mr. Sumler. Today is the day and time scheduled for hearing on the plaintiff's motion to change their name. Did you receive a copy of that motion, sir?
No, I did, ma'am. All I got was a subpoena 6 days ago. I don't even know who Capital Razor is.
I'm sorry, all you received was a subpoena?
Yes, all I got, ma'am.
Not probably a subpoena, sir.
I didn't get any paperwork from this company. I don't even know who the company is.
Sir, how did you know to come to court today?
I got a subpoena 6 days ago.
Okay, do you have that subpoena there with you?
Yes, I do, ma'am.
Okay, what does it say at the top? Oh, sir, that's a notice to appear. That's not a subpoena. I just wanted to make sure you had not actually.
This is all I have. This is all I've gotten from this company.
Oh, sir, okay.
I'm sorry.
That's a notice to appear. That's something that the court sent out.
Okay, well, that's all I've gotten from this company. I don't even know who this company is.
I'm looking to see if the attorney, I don't see the attorney here on behalf of the company.
Yeah, that's why when I got this notice to appear, I was surprised because I was like, who is this and why did I get this?
Mr. Sumler, this court received from the plaintiff Razor Capital a motion to change the name of the plaintiff from Razor Capital to Absolute Resolutions Investment. The court asked the staff to schedule the matter for hearing. The case was scheduled at 10:15. It's now 11:06 by the court's clock. The plaintiff has not appeared this morning. It's their motion. Do you have any objection to the plaintiff's name being changed?
Ma'am, I don't have an objection, but I don't even know who this company is. I never dealt with Razor Capital. I never got any information from them. So
Mr. Sumler, this case dates back to 2015.
2015. I still don't even know who this is, ma'am. I haven't made any payments to any capital banks at all, or any other names that they may have used. And there's more than one Edward Sumler that exists.
Well, Mr. Sumler, this case has been with this court since February of 2015. There have been tax garnishments filed along the way. I don't know if your taxes have been intercepted towards the payment of this judgment.
Okay, now I know who it is. Okay, I don't have any
Now you know who it is?
Yeah. You said they've been garnishing taxes, state taxes.
Yes, sir.
Yeah, okay. I don't have an objection to the name change.
The court will grant the plaintiff's request and sign the order that was attached to the motion. If there's nothing else, Mr. Sumler, I'd like to thank you for your patience this morning.
Okay, thank you, Your Honor. I do have one question though. Since
Yes, sir.
they were actually using an attorney that I paid my payments through, am I still paying my payments through that attorney just because they changed their name?
Yes, you're still
Okay.
using the same address unless you receive something from them directing you to do otherwise.
Okay, so this was just all a name change.
Yes, sir.
Okay, I don't have a problem. Okay.
Have
Thank
a good
you,
day,
ma'am. I
sir.
appreciate you.
You're
Okay.
welcome.
All right. Be blessed. Have a good one.
You too.
All right. Bye-bye.
Ms. Johnson, my policy is 15 minutes after the scheduled start time. So if the plaintiff and the plaintiff's attorney have not appeared within the next 6 minutes, I'll call your case and let you get on with your day, okay?
Can you hear me, Judge?
Yes, ma'am.
Oh, okay. I couldn't hear you a minute ago. I thought you said something about 6 minutes, but I was trying to say something, but I couldn't hear you.
Just wanted to make sure you heard me say that I call cases about 15 minutes after the scheduled start time. So if the plaintiff and their attorney are not here by 11:15, I'll call the case, which is 4 minutes from now.
Okay.
Thank you, ma'am.
Thank you. Thank you.
This is 2302576 GC. This is Mekanen Tedla versus Shantu Johnson. Ma'am, would you unmute yourself and state your name for the record?
Yes, Shantae Johnson.
Ms. Johnson, today is the day and time scheduled for the bench trial on this matter. The case was scheduled at 11 a.m. It is now 11:16 by this court's clock. Neither plaintiff nor the attorney of record have appeared for plaintiff this morning. How would you like to proceed?
I'd like to just dismiss it.
This case is hereby dismissed. Anything further, ma'am?
No, thank you, ma'am.
You're free to go. You have a great afternoon.
You too. Thank you.
Thank you. This court stands in recess until the 1 p.m. docket.